We'll call the meeting to order. It's now 3:39, so that wasn't too bad of a delay, and I thank them for taking care of that. So let me just pull up our agenda. And well, first we'll have everybody identify who's here. And I think, so we'll do the roll. Obviously, I'm here. Judge Altermat, Judge Spader, Travis, Attorney Generous, yes, you're here. Attorney Gentis. Attorney Pocklington is not here yet. Before we were on the record, Becky reported that he is still on the record in his proceeding and that he'll join us whenever he can. Attorney Salato is here, and Attorney Douglas Ortiz, and of course, Becky Schmidt. So we are almost fully contingented and have a quorum. So the first item on the agenda is the approval of the minutes from the July 30th, 2025 meeting. I would entertain a motion. Oh, who said that?
Moved. I always say it.
I'll second.
Thank you, Judge Spader. I'm sorry, the little recording thing. Can I move this? No, I can't. It's blocking your face. So I didn't know who said that. Thank you. Was there a second?
I'll second.
All right, thank you. That's Attorney Gentis. Is there any discussion? Hearing none, all those in favor?
Aye.
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 All right, I think that was everyone, but any abstentions? I'll just ask so we're clear. And any opposed? Motion carries unanimously. All righty. And now going on to old business. Let me just put. Okay, so the first item on the old business is the issue relating to the motion to open and the clerk procedure. You'll recall that in looking at the minutes to refresh your recollection, that we had a proposal that we sent on behalf of the committee to Judge Bellis. There was a vote unanimously by the committee to make a proposal with regard to motions to open that were filed with case flow requests on the eve of a sale or law day. Do you all recall this, and have you looked at it in the minutes? Okay. I did hear back from Judge Bellis, who indicated that she is not supportive of the proposal. There were some things in her summary that I just wanted to have an opportunity to clarify with her to make sure that either I was not understanding her or she wasn't understanding us. I wanted to make sure that we were all on the same page. So I followed up with her. I had the opportunity to speak with her actually just before this meeting, Becky, so I didn't even get a chance to tell you, but it was consistent with our discussion. So I followed up to make sure that she understood what our proposal was, that it was limited to those circumstances of last minute motions to open where the case flow request is filed asking for early adjudication and the sale date is the next day or the law day is the following Monday and they're filed on a Friday. And Judge Bellis firmly opposes having case flow do anything. She indicated that court operations also opposes it. Logistically, they feel that it is not something that is feasible for case flow to take on, and also that in considering fundamental fairness issues, that it shouldn't be case flow that does that. And her feeling was that the attorneys for the plaintiff should be encouraged to, if they're not already doing so, to check from whatever list they have of sale dates that are on that weekend or law days that are the following Monday, to check the court docket for any last minute filings that you may have gotten or may not have gotten that may have been filed that either didn't indicate consent, or sometimes I know we talked about where it says that the person didn't have a chance to respond, but the motion was filed at the end of the day on Friday and you may have gotten a message at that same time, so there wasn't an opportunity. Or if it indicates consent and you hadn't been contacted, that it should go to the plaintiff's lawyers to basically have that system in place to check that, and that it would probably be easier. I'm paraphrasing, but this was consistent with what she indicated to me. Also, when judges receive those case flow requests, they can handle them as they ordinarily would see fit to determine, whether there was appropriate time provided for when somebody says there is not sufficient notice, and the case flow request is filed in the 11th hour, or can handle it however they see fit, rather than having a set procedure by case flow or the clerks to follow. So with that, you'll recall that when we passed that motion to make the recommendation, obviously it goes through Judge Bellis first, and then if Judge Bellis, as the head of civil, is not in favor of it, and she's indicated also that Court Ops as rigorously opposes it as she does, that it does not make sense for us to then pass the recommendation on to the Chief Court Administrator's office. Does anyone have any questions, comments, concerns about that? That's the report I have on that one.
I think that my main concern with raising that at the last meeting was more so when a defendant indicates consent on a case flow request, but hasn't even reached out to our
Right.
office for consent, because most of the time when the court receives a case law request indicating consent, it just goes right to the judge. There's no
Yep.
other procedure in place. So that was my main concern. It wasn't so much the late filings, it was more so the issue of consent. But if Judge Bellis feels that way, then Judge Bellis feels that way.
And I did, just so you're aware, we reported it, Becky and I put together the language that, and Becky, feel free to pipe in, that included that there's frequently times where the forms will say there's consent and the opposing attorney hasn't even been made aware of the filing. And the thought process that was conveyed to me is that since the plaintiffs are aware what sale dates and law dates they have coming up, that it would be more appropriate for the plaintiff's lawyers to have a procedure in place to look for any last minute filings on those, let's just say it's on a particular weekend, then you would look for those sale dates or law dates online, because everything's online, of course, and see if there have been any last minute filings that you weren't made aware of. I mean, I know it's not what we had hoped for, and the committee voted to make the proposal, but that is what I have to report to you. Becky, did I leave anything out, or do you think I misstated anything in that summary?
No, Your Honor, you got it all. Thank you.
All right. Any other comments? Is there a way
Might
that
I
I
just
can?
inquire, because I thought our what we voted on was simply that before it comes to me for signature, case flow make a reasonable effort to check
Right.
with plaintiff's counsel. So that's just a phone call. So now
I get it.
might understand that it's against policy for me to have my deputy clerk reach out to a Collar Raymer and say, hey, did you really agree to this or not? I mean, is
No,
that what I'm hearing?
That's a fair question. That is why I followed up. That was my, we submitted the proposal exactly as the committee had intended it. The response that I got is the judges can make a determination of how to handle their case flow request however they see fit. So if it comes to you and you're not sure, it comes in at, this happens to us a lot. It comes in at 4:30 on a Friday for a sale date on a Saturday and it says consent. If you were to reach out, you as the judge would be able to handle that as you see fit. They just, the proposal to have that done automatically, by the clerk's office, or would presumably be the clerk's office as opposed to case flow, but by anybody in the staffing role on their own without the court's input is not something that they're willing to do. So the sense, and I wanted to make sure that I was reporting this in the way that she intended the message to be communicated. And basically the gist of it was the judges can address that case flow request as they see fit. And the plaintiff's lawyers may wish, if they're not already doing so, to have a procedure in place from their list to see if there are any last minute filings. Does that answer the question, Attorney Altermat? Judge Altermat, sorry, I just changed your title.
I do it to myself all the time. Yep, that answers it fine. I can do
So
it
you can,
as I see fit.
exactly. So, I mean, I do the same thing. So if there's a circumstance where it's unclear to me also, I will ask my clerk to do the same thing, to just confirm it's not taking a position. It's not trying to do anything in advance. It's simply the same thing that you're doing to make sure that if you're ruling on it, that we know if it's by consent or not. Any other questions, comments, concerns as it relates to that one? Hello, Attorney Pocklington.
Hello, everyone. Sorry for my late arrival.
That's all right. Attorney Schmidt, let us know that you were on the record and you would be joining us as soon as you could, so we will note your presence. Anything else on that one? All right, thank you, everybody. Then we'll move on to the next old business, outstanding, which is signs on the property. And this was one you'll recall that we had talked about if anybody had any information that related to things that may have come up. But why don't I turn to Becky? I know Judge Bellis wanted additional information. We indicated last time that if anybody had information to respond to the specific questions, they could send that information to Becky, and we would have that information circulated, which you folks had in the email that went out. But Becky, did you want to pipe in on that one?
Sure. So just basically on the signs on the property, I just tried to summarize what I received. So it's not all inclusive. So if any the submission, if anyone wanted to weigh in and kind of broaden or clarify what that was, but basically based on the summary provided, we were kind of with the same information as prior, that we're unaware of any other state that requires a sign on the property. Again, Vermont being the only state that we're aware of that does sales curbside or near the property on the sign issue, and that we don't really have any way, except for anecdotally, to determine whether or not it's a benefit to the sale price. It doesn't seem to be, but nothing empirical that we can provide on that. And then a couple of responses indicating that there are circumstances where homeowners have become aware of the foreclosure by sale having been ordered because there's a sign on the property, either maybe there was one specific instance where they didn't reside there, they resided elsewhere. So there is a notification aspect to a non-appearing defendant, and we are aware anecdotally that that does occur from time to time. So that was the summary.
Yeah, and it's, I think the mediators could probably weigh in on this too. I know, how sometimes when you notice a red car, all of a sudden now you notice all these red cars. It's kind of the same thing. I think we talked last time about circumstances where people might, in particular, non-appearing defendants, as Becky indicated sort of in that list, that sometimes the first notice that they have is the sign. So if we take the sign away, if that were a consideration, then, does that prevent the person who their only notice of the sign, the only notice of the foreclosure is that sign going up? Sometimes, and the reason I use the red car analogy is because although I know it has happened, I noticed it more after we had this discussion where non-appearing people would file an appearance just before, after the sale date had been set and the sign went up, and they would show up for a hearing on a motion to open and say, I had no idea, either because, they don't check the mail, they didn't see it, it's blown away, somebody else in the house may have gotten the information and not shared it with them. All these other circumstances where if that sign weren't there, they wouldn't even know until people showed up for the sale. So those were some of the circumstances that I know we talked about before. And Becky, if you just want to, I know we talked about this before, but if you just want to reiterate what Judge Bellis's request or concern was before we open this up to others to talk.
Yes. So the concern, and I'm sorry, I'm just pulling up the materials. The concern was that the opt-out model of the having the sign on the property where there's an appearing defendant versus having a mandatory sign on the property for non-appearing defendants. So she asked for a little bit more information as to what other states do. She asked for information if we are aware of what situations a sign is the first time the homeowner has notice of an upcoming sale, and how many times have we, become aware that a homeowner has done something in relation to the sale because of the sign. So they may have been aware of it, but not done anything until the sign was a very real, tangible thing that they did. I believe she also had a further question. I'm just trying to find it. On,
With regard to appearing and not appearing.
Correct. I'm just pulling up the minutes.
Sure. There was a question that is there something else that's being missed beyond the sign that's
Yes.
causing the defaults? I don't know that we would be able to answer that. I'll hear from what others have to say, but I don't know that we could answer that. But one of the other issues, I believe, and I know it's not in the minutes, wasn't there a concern also about treating non-appearing defendants differently from appearing defendants? And that's why these questions were relevant for the consideration on her end. Did I say that right?
I think that to put it like as plainly as I can think of it, is that if it's embarrassing for appearing homeowners, it would also be embarrassing for non-appearing homeowners. So why would the recommendation treat one differently from the other? And just more information regarding that thought process.
Yeah, and I think there was no indication that if it applied to everybody that she would be in favor of it. But it appeared also that this was a consideration, as Becky said, why. And on the second one, I think there's been more information voiced as to why, if there were going to be a consideration of not having the signs for one and not the other, why there's a reason for it. But I don't think that ends the inquiry of whether or not she's going to support this either way. Just so we're clear on that. I would like to hear from the mediators to start with on if there's anything else that you folks want to say about the sort of anecdotal information that we're providing on the non-appearing defendants and their action in response to a sign or anything else.
Definitely, Your Honor, Attorney Douglas Ortiz. And so after our last meeting, I went back and took a look at specific cases that I knew the homeowner had filed an appearance and appeared in mediation because of the sign. And then I did realize that there was a non-appearing homeowner who was a divorce matter where the one party stayed in the property, didn't appear, and the divorced person who was out of the property drove by the house and saw the sign. So neither of them had appeared. And that's what prompted the action for the homeowner out of the property to come to the court and file an appearance and find out what was occurring. So it's kind of, it's kind of a catch. There is the benefit to the sign as embarrassing as it is. I found a handful of cases in Middlesex court specifically where that sign triggered a homeowner to do something.
Right, thank you. Attorney Claxton, do you have anything to add?
No, I don't have much to add to what Attorney Douglas explained, but I do think that the sign does activate some behaviors on any party to start to address whatever foreclosure actions that have commenced. So I think those signs are sometimes helpful in those situations.
Okay. All right, so now I'll open it up to anyone else that wants to speak on this issue.
I'm going to reveal my ignorance as if it isn't pretty clear to everyone without me revealing it. Is the sign required by statute or rule or practice book, or is it custom? Is it like somewhere written down that there has to be a sign?
It's a custom and then sort of assumed that it exists in a standing order.
I was just gonna say,
Okay,
it's the
standing order.
JDCV
Anyone want to verify, or anyone have?
I think it's the JDCV 79 off the top of my head, but I'll double check that while we're talking.
That's
Say
something
that
Yeah,
again,
that's
Attorney Pocklington?
Thank you. Yeah, it's definitely in a standing order.
Okay. And then can we all agree that the premise of the sign is to benefit both the plaintiff and the homeowner by presumably maximizing the value of the property by getting the highest bids from the greatest number of people?
I would agree with that. I know, though, Attorney Judges, this was your proposal, so I don't know if you want to weigh in on that.
Certainly the premise. I mean, you have a forced sale that by its nature is not fundamentally is not going to get fair market value, and the sign is thought of as one way to fix that. In the same way that advertising might fix it, and that's all.
And I'm not suggesting that I'm down with signs. I'm just trying to understand kind of like the premise behind them.
No,
And then
that's the
question
premise
for
is
us
certainly
judges is,
yield.
if there was an appearing defendant with a lawyer and I'm doing the sale and they say, Judge, I want to save my client $350 and my client doesn't want a sign, and the bank's lawyer says, I don't care about a sign, would I as a judge allow everyone to waive the presence of a sign? I probably might. I mean, I'd probably get in trouble with somebody, but if there's nobody who cares, I'm often of the mind, if nobody else cares, why should I care?
I think as a standing order, right? You could waive it, and I don't think it occurs to people that could be an option, right? It's always assumed that it must be. So, yeah, I mean, the thought was if you put it out there as this is a thing that could be waived, right? More people would take you up on it.
Well, maybe that's a different it's sort of a modification to what was on the table, the concept of proposing that the sign can be waived, as opposed to what we have been talking about, at least my understanding of what we've been talking about up to this point. People want to weigh in on that? Anybody?
I know, speaking from a practitioner perspective, I've never had a problem with a homeowner's attorney saying my client doesn't want to sign, or even a pro se saying they don't want to sign, as long as they understand that then they kind of can't come back later and contest the sale approval on the basis of there wasn't enough interest or there wasn't enough. It's kind of a, if you want to make your bet in that regard, that's absolutely your discretion, but then sleep in it situation. But ultimately, keep in mind, we don't require the standing order, and I did confirm it is the JDCV 79 uniform standing orders for foreclosure by sale. The standing order does not require signs in all sales, as I think we all know, but just to refresh us, if it's a condominium, yeah. So there's already a large number of files that don't have a sign. So allowing a borrower to opt out at the judgment hearing or by written request prior certainly has merit and addresses my underlying issue with this is that we've got competing reasons why it's good and why it's not good. It's the notice versus the stigma, and those aren't really opposites of one another. It's hard to balance those, but if a homeowner is more concerned about the stigma, then they should have the ability to raise their hand and say, no, thank you. But in the absence of a homeowner raising their hand, the notice may be more important.
Obviously this suggestion, this sort of morphing is different and new. So this is a gut reaction. But without hearing more, my gut reaction is that this one might be an easier proposal as opposed to changing the policy across the board to have some sort of a proposal that allows it would be the borrower, I get it, but the plaintiff would have an opportunity also, should they choose to object, but that some sort of a proposal that the borrower could opt out of the sign. Please tell me, folks, what anybody has to say about that, either for, against, or just informational.
I think that makes perfect sense. If the defendant wishes to appear at the judgment hearing and request there's no sign be placed on the property, I would have no issue with that. I mean, ultimately, it increases temporarily cost to our client regardless, because if a sale is ordered, a sign is put up, the sale is extended, we're still paying the committee for the sign. So if the borrower wants to waive the sign, I would have no issue with that. I mean, it would require the defendant actually appearing for the judgment hearing and waiving that requirement for a sign.
Right.
But if they want to do that, I have no issue with that.
Anyone else?
I think it's more might be an educational thing of just letting judges know that it's not statutorily required. It's, by rule, and they have the discretion upon request of the parties and should exercise that discretion appropriately based on the matter before them from the parties.
Right. So what would happen if this committee chooses to make a motion and it carries? Remember, we're an advisory committee, so we would put together a proposal to Judge Bellis that the committee would submit that the parties or the borrower be permitted the option to seek to waive the sign, with all the language that we need to with regard to that. And as part of that, if it passes, there would be, as she always does, Judge Bellis would send out something to the courts to indicate that that is an option. So I mean, Judge Rohraback seems to think that it's an option now. So I don't know if maybe it's just a matter of, and I think you're right. I don't disagree with you. So I'm not saying you're wrong. I'm just saying, but to maybe make it known, because there is in the standing order, there is express language with regard to the sign, other than, as James correctly pointed out, condos, which is primarily because they don't allow signs in there. But so what are your thoughts? I mean, do you think it's something we need to do? Do you think it's something we should do? Do you think we leave it alone? Do you think we ask if there can be, as Judge Spader suggested, some indication, assuming Judge Bellis agrees with us that we can do this, that we have something circulated to let the judges know? I mean, if there's going to be something circulated to all the judges to let them know, I, for one, am uncomfortable doing that without making sure we have the correct support for that, because we are an advisory committee.
If I can make a suggestion,
Yes.
the current language in the standing order is, quote, the sign must be placed on the premises, and then it goes on to discuss the mechanics of it. I'll be honest, I think this may be as simple as suggesting a slight tweak to the standing order of the sign must be placed, the sign unless waived must be placed on the premises, and that makes it blatant that in the standing orders that waiver is an option, and then we don't have either judges thinking that they can't or that they shouldn't be, or being concerned about overruling Judge Bellis's standing orders by making it express that waiver is an option.
And then waiver by whom? Then going back to who's the benefit? Is the benefit the plaintiff or the defendant? Unless waived by both the plaintiff and the defendant.
Unless waived by the court was my intention, Your Honor.
Or by the parties.
Maybe by the parties and approved by the court.
Or just unless waived by the court for good cause.
Unless ordered by the court.
Generic, but, yeah.
Just, I mean,
both we're talking at the same time, so give me the language that you're proposing.
My proposal would be line 11 of the JDCV 97 to be amended from the sign must be placed to the sign unless waived by the court must be placed.
I think that it would be so ordered by the court. I don't know if the court waives
I think it should be waived by the parties. Waived by the parties and ordered by the court.
I think so too, because the waiver doesn't come, Jeff's right, the waiver doesn't come by the court, but the order has to come by the court because that allows the opportunity for the parties to be heard. So I think that I want to hear what everyone else says, but unless waived by the parties and ordered by the court, right?
If I may, Judge Bayo, just suggest that waiver be solicited. So when the judge is doing their litany of, all right, I find that the property value is, $80,000 to the land, $300,000 for improvements. I'm looking at a sale date. We talk about the sale date, and then I'm going to, for the sake of a sign on the property, the parties have a position on whether or not they would wish a sign to be placed on the property. I realize that could add anywhere from 8 to 40 seconds, but
and that, I totally agree, because as we're sitting here, Attorney Geddes, I'm thinking, what the heck? If I think I can do this anyway, in those rare cases where the defendant is represented by counsel and we're at a hearing setting a sale date, why the heck wouldn't I say to the lawyer for the defendant and the lawyer for the bank, you guys don't need to sign, do you? And they could say, nah, we don't need to sign. You don't want to.
And I'm just telling you, like 2013, Jeff, never thought that this would be conceivable, right? Because I had clients who were like, this kills me. And I was like, I can't do anything.
Yeah.
Right.
I
So
think
with
that it actually does make a lot of sense too, because
Yeah.
in the past, I'd say maybe 10 years ago, when the court entered the judgment, they would read off every single detail about the judgment, the bar date, the sign date, everything would be read off as part of the order. Now, at least in my experience for most of the courts that I've been to, there's not even a mention of the sign when the judgment enters. So that's not even something that would just come up and the defendant would be aware of to waive that requirement. So I do think it would need to be somehow part of the court's process for entering the judgment order, just because I don't think anyone's going to bring it up on their own.
Well, yeah, but the plaintiff always says, but make sure to waive the deposit if I'm the successful bidder, waive my presence at the sale. So
we're a little bit more experienced than most defendants, so.
No, but you could also ask the sign waiver is benefiting you too, because it's $350. It's not going to come out of your pocket ultimately.
Is there
I will
any
suggest-
value?
Oh, sorry. I say, as a term of art in our standing orders, to preserve judicial individual discretion of the judges, often they will drop in a line somewhere. I don't know that it's on this form. I haven't looked in a while, but unless otherwise ordered by the court, which just is the trigger for, like, you have the discretion as a judge of the Superior Court to do whatever you deem fit under the statute. So that's just another common term of art that is often used in the standing orders.
It's right there in bold at the top, but by the time we get down to the sign, we're not quite onto the next page.
Yeah.
But yeah,
I agree. I think even though it's there, it's not clear, in particular because of custom and practice. The suggestion, if everyone's on board with it, and in a moment I'll ask if there's a motion, it would need the additional language in order for it to make any sense or have any awareness by the parties of this issue. And the language that's been proposed by Attorney Gentis, Attorney Pocklington, and Judge Rohraback, taken together, may be an easy way, at least in my view, an easier way to do that without turning everything on its head. But so I don't know if we want to take this in two separate parts or together, but with regard to the request for waiver, I completely agree that the judge should then, if this passes, ask that question about waiver. How do the parties feel? Do the parties want the sign? How do you feel about the sign? But how do you folks propose that should be included in, if there's a motion to be made for the recommendation?
my
Or should it be?
suggestion is to change the language, but let the sort of the canvas of the parties, which is very idiosyncratic to every judge, sort of go out through whatever connections and not necessarily be part of the formal recommendation. Because I know, for example, the annual judge training on foreclosures for new judges, they pick up a lot of the style of whoever is doing that particular training, and most of them keep it. So
Anyone else want to weigh in on that?
I think word will get around if we
Yeah.
start waving the sign. It'll just, like, people talk to each other, lawyers talk to each other. I just think it'll just make kind of ease its way into the lexicon. I have more confidence in that process than in trying to tell judges to remember to do it.
Right.
I don't want to
That would-
speak for the mediators, but I think it would be bargained for in mediation as well if it was a graceful exit.
Yeah.
I agree,
Mediators have
Becky.
anything?
Yeah, I agree. It's something that we can, canvas with both sides as we, prepare for, liquidation options. We can absolutely share that the sign it can be an optional, agreed upon position by the parties.
Attorney Claxton, anything to add?
No, I agree. The sign can be an antiquated process, but yeah, I definitely agree with what Attorney Douglas explained.
Okay. Anyone else have anything to say with regard to this matter? So is there a motion to be made for a recommendation by this committee?
Just because I love the sound of my own voice, Your Honor. I move that we amend line 11 of the JDCV 97 standing order, or recommend amending the line 11 of the JDCV 97 standing orders. I believe the language that we arrived on was the sign, comma, unless waived by the parties and approved by the court, comma, shall be placed, or must be placed, must. So we just insert that clause that we talked about right there, and Judge Bella signs off. That enshrines that discretion we're talking about.
All right, so we have a motion on the table. Is there a second?
I'll second. Attorney
Okay,
Douglas Ortiz.
thank
Can I
you.
make a friendly amendment to make it 79 on the
Oh, as
form
opposed to
number?
97. Attorney
Yeah.
Pocklington, I think
Sorry,
you just
yeah, no,
reversed
that
the
was-
numbers.
Yep, I just juxtaposed the numbers in my head. Thank you.
Do
Sorry.
you
Thanks,
accept
Jeff.
that? Do
Of
you
course.
accept that friendly amendment? All right.
Thank you,
And do
Jeff.
we still have our second?
I'll second.
All right. With that, we have a motion as amended on the table. Is there any further discussion?
Just, I hate to do this, but
No,
just a
it's
quick
okay.
question. Right now, the way it's written is if agreed to by the parties and agreed and accepted by the court. We all know that a lot of times there's going to be 6 or 7 parties. A lot of them are not appearing. So do we make that as agreed to by the appearing parties or the main
Party-
defendant? I mean, we don't want to have to get an agreement from people we know are never going to show up, the United States and the Department of Revenue Services. So
The parties present at the judgment hearing?
Well, no,
That was-
because we only want to do it when the defendant is represented by
Right.
counsel and yeah, so
Oh,
we
but
kind
the-
of have this.
But I think it's not just for when the defendant's represented by counsel, right? I mean, they could decide to waive it on their own or say
Right.
they
Well,
don't
no,
want
I'm
to
sorry,
sign.
when they're appearing at the judgment hearing, forget
Yeah,
about
yeah, that's
represented
what I'm
by
saying.
counsel.
From the parties appearing at the judgment hearing.
So, all right, now it's my turn to say I hate to do this, but because we were getting into the issue of the benefit of the sign for non-appearing defendants, for which there has been
Right.
comments made in particular through the mediators who are the front line, I don't think we can, I think that it would be hard to do it when there are non-appearing defendants.
Okay.
Because of the equity, what Judge Altermat was saying, when we got all these, the DRS and the judicial
Right.
branch and probate court, whatever, they don't care.
How about the parties who appear at the judgment hearing, including the any appearing defendant mortgagors?
No, but see, the problem is the appearing, because that
Right.
doesn't resolve the issue. The issue that we were talking about initially
Yeah.
was what happens for the non-appearing defendants. That sign may prompt them to do something. So they're not going to appear at the judgment hearing. What we usually see is motions to open coming afterwards, or late filed requests for mediation coming after. So in conjunction usually with a motion to open. So that's the problem. I think that there's somehow, my own view, and I open this up, is that in order to be sensitive to the initial discussion we were having and these concerns about fairness to the non-appearing defendants and the benefit the sign may present to them, that there needs to be something to indicate that this can only apply when there are appearing, I guess, individual defendants, or something to take out those entities that Judge Rohrabaugh mentioned, like when we have the U.S. as a party, or, MDC, or like the people that we know, it's the state DRS, that kind of thing, where we know they're not going to appear and they're not going to take a position with regard to the sign. But individual non-appearing defendants, that's the whole thing we were talking about up until just a few moments ago, about the concern for those folks having notice.
I'm talking way too much, but I apologize for that. But Attorney Pocklington, did you say that the standing orders already say unless otherwise ordered by the court?
They do at the top of the standing orders, yes, unless otherwise ordered by the court, colon, and then 2 pages or 3 pages of details.
Well, then I'm kind of the opinion, we've already got the ability, I'll be the guinea pig. The next time I've got a foreclosure by sale and I've got a bank and I've got an appearing owner of the equity, and I'm going to run by them, hey, do you guys want the sign or not? And I'll take my chances in terms of if anyone wants to challenge me on that.
And here's another thought, just which may sort of like to try to bring these two sides together. I know it's already there. I know it's at the top of the form, but I also think that James's or Attorney Pocklington's comment that it's further away is a valid one. Is there any harm in repetition? Is there any harm in using the language that Becky just mentioned? It's at the top of the form and just indicate that the sign, unless otherwise ordered by the court, must be placed.
Unless otherwise ordered or waived by the court, must be placed.
The court doesn't waive anything.
Oh,
The court,
right,
the
we
parties
can't-
waive
Yeah,
things.
So this would take out that the party's waiving part. It would still say exactly what we're saying at the top of the form. So yes, I get it. It's redundant, but sometimes redundancy makes sense if it brings clarity.
Right.
And given the separation of where these items are,
I'm all for that, and we don't have to get into the parties appearing, non-appearing,
Right.
That's too
And
much.
I think that does make a lot of sense because something just popped into my head while we were discussing this. If there is a subsequent lien holder who actually wants the sign to be placed, so they think that there might be more bids at a sale, they might get more money out of the sale. That could also be something that comes up. It's relatively rare that any subsequent lien holders even show up for the judgment hearing, but I have had situations where they do appear and there is a substantial amount of equity and they're looking to maximize the amount of their lien that they recover from any sort of supplemental judgment. So that is a kind of an oddball situation that might come up. And if we only require the agreement of the plaintiff and the mortgagor, and then the subsequent lien holders come in and say, wait a second, we want a sign to be here. We want to try to maximize the sales price. That might be an issue. So I think by just repeating the language that's at the top of the form in this section, that would probably resolve any issues. Ultimately, it's up to the court to issue the order. If there's argument about it, if someone disagrees, the court can always require the sign. So I think that probably resolves the issues.
anyone else? Attorney Douglas, did you have anything? You look like you were going to say something.
I'm trying to
I
type some
was
link.
g- I-
Oh, sorry, go ahead.
No, that's okay, Jeff. I was going to say something, but that's okay, Your Honor. I'm all set. Thanks.
You sure?
Yeah. Yeah, I am. If
Okay.
it comes back, then I'll definitely share with the committee.
Okay. Attorney Gentis, you had something. Travis, I'm sorry. Attorney Claxton.
No,
I'm
I-
not sure
I-
who was first from the faces.
Well, I don't know if it kind of takes away from the other 22 spaces in this order, right? So our point is to emphasize and let parties know that they have that option to have a sign or not, right? So putting unless, again, is helpful, but would it be helpful to bold it, number 11, to bold that standing order? And I mean, I guess this is also assuming people are reading that standing order too, right? So would bolding it help at all? If we have
Bolding it.
violation-
If people read the standing order, it might help, Attorney
Yeah,
Claxton, but
that's
we don't
true.
have to worry
Yeah.
too much. It's not a
Yeah.
problem we have too often.
Yeah.
You
I
mean
think the
bolding
main
if we
goal is
add the
to-
language? I'm sorry, I'm trying to understand. Or you mean bolding the whole thing?
Yeah, bolding the entire thing. So in number 12, we have violations subject to punishment by the court, right? So I don't know if bolding it would help too, but I mean, that again, that's assuming people read it.
Yeah.
I think much to Judge Rohrback's point, I think the goal in doing this is to make the judges aware that this is an option. Once that happens, I don't think we're going to need people to be reading the standing orders. I think that the main goal here is to make everyone aware that it is not necessarily a requirement that the sign has to be there, that it can be waived upon order of the court. So whatever we can do to make the judges aware of this, I think will then trickle down and make it so that it becomes a part of the regular procedure.
All right. So then I will offer as a motion to amend the motion that's on the table
Hmm.
to say, in lieu of the language proposed in the initial motion, that the language, unless otherwise ordered by the court, be placed in the appositive before must. I don't know if there's that's my motion to amend.
I would second that.
All right. Any
The only-
discussion on the amendment?
The only thing, I tried to memorialize what we were tinkering with before, though the ship may have sailed.
Yeah, I mean, that still talks about parties appearing at the judgment hearing, which doesn't address the issue of non-appearing defendants. Is there anybody else that has anything to say on the proposed amendment? All right, so I will call for a vote on the proposed amendment. All those in favor?
Aye.
Aye.
Any
Aye.
opposed? Any abstentions? All right, so the amendment carries. Now we go back to the motion as amended. Becky, are we making you crazy?
I'm scribbling notes off to the side.
All right. So the motion as amended, Attorney Pocklington's motion as amended is that line 11 of JVCD 79 be amended to, paragraph 11 be amended to indicate the following language, unless otherwise ordered by the court, comma, before the word must as it relates to the sign. Is there any further discussion as to the now fully amended motion? I think we might have gotten there. All right, so now I think we're ready for a vote. All those in favor signify by saying aye.
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 All right, I think that was everyone, but I'll just ask, any opposed? Any abstentions? All right, the motion carries, so we will put together a proposal to Judge Bellis that reflects that motion. Thank you, everybody. I think that was a great discussion. The next thing we had on has been tabled, and as you know, and we talked about last time, tabled items stay on the table unless somebody moves to take them off. We had a long conversation about the issue of holding sales at the property, and that was tabled at the last meeting. So that moves us on to new business. And the first item was something that was on our agenda for the last meeting, but we ran out of time and didn't reach it. So it's still on as a new business item. And Attorney Pocklington, I believe this was your proposal for new business. Did you want to start that conversation?
That wasn't mine.
That wasn't you?
No. Not notice of it, just the fact that it happened. But I think at this point, given the passage, I'm not sure who put it on. I don't remember it being me, but if it was me, I think at this point, passage of time, that ship has probably sailed. I think everybody knows that we now have a statute of limitations effective next year. But I don't think we need to do more with that.
All right. Anyone else have anything to say about that agenda item? Okay. Then we move on to the next one, which is the proposed meeting schedule. Becky has included a proposed meeting schedule, which is consistent with the timing of the meetings that we've been holding to date. And you can see that they are quarterly, starting with January 28th. Does anybody have anything to say about that before we vote on the proposed 2026 meeting schedule? Right, so I would entertain a motion.
So moved. That be the meeting schedule.
All right. And is there a second?
Second.
All right. And so we have Judge Spader, Attorney Pocklington for the motion and the second. Any further discussion? All those in favor signify by saying aye.
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 All right, and I think that carried unanimously, so we're good on that one. The last item we have, oh, I'm sorry. You know what? I was looking at the prior agenda and I skipped new business number 2, which was we received a letter from one of the committees who was concerned about the timing of payments to the committee. And Becky, you put that in your email, right? Let me just pull it up.
Yes, it was very generic, the timing of the payment to the committee once the proceeds of sale had been received, waiting for supplemental judgment.
Okay, hold on. Let me just pull that one up. Where's my attachment? Sorry, my computer is not cooperating with me. Hold on. Okay, there it is. So the proposal that was made, so there's two issues. There's the concern as it relates to the timing of payments. The proposal that was made, and if anyone wants to see a copy of the actual letter, let Becky know. I'll have her circulate it. We didn't do that just because rather than sending it all out, we figured we'd talk about it. But the proposal was made that the committee hold the sale proceeds instead of having them deposited with the court. I know. I had a hunch that that would be the reaction. That was my reaction too, but I am obligated to bring it to this committee. And, you know, beyond that, I don't really know what else to say. Becky, do you have anything to add to that?
Again, I think that the concern expressed was, you know, timely payment to the committee. We know that there are instances where the payment is held because of the supplemental judgment takes a while to come through, even though we know they're going to get paid. So I share Judge Bayo's concern with having the committee do anything with the funds besides bring it into court, because there's no fiduciary relationship with the successful bidder and the committee. The committee is doing the court's work. So I think the proposal was just to see if there was any other way that we could ensure that the committee gets paid on a timely basis. And I would assume that the committee paying themselves is probably not something that we can do.
And I could tell from the expressions that I'm seeing and the head shaking, although there haven't been any comments yet, but I am happy to hear from you folks. But I agree with what I've seen in the body language. I think that for a variety of reasons, including those just mentioned by Becky, this is not a proposal that would be appropriate and could be very problematic. And I'd like to hear what others have to say, but my feeling is we already have, if somebody feels they haven't been paid timely, you know, people file motions. There's already a procedure in place. And, you know, sometimes cases take longer than others to resolve. I get it. There could be motions for, you know, we've had a number of them where the supplemental judgment hasn't been filed and the court can enter orders to that effect. So I don't know if anyone has any ideas, if there's a need to do anything else or not. First, let me take the first step, which is there anybody that disagrees with, and again, I don't want to speak for what I saw, but is there anybody that thinks that any action should be taken as it relates to the proposal for the committees to hold the funds? I know.
Frankly, I think that many committees wouldn't want to hold the funds. That's a whole nother level of responsibility for them that I don't think most of them want. So I can't imagine most committees would be in favor of this.
Well, and I agree with you, but and the other concern, though, as Becky pointed out, is the lack of a fiduciary duty. Also, I'm sure that we all have war stories. I mean, we had one, and I think Attorney General, I'm not sure, you might have been on this one, but where unfortunately, you know, committees like anybody else can have issues. And we had, oh, that was you, James? Attorney Pocklington, I'm sorry for using informally first names, where the appraiser didn't get paid even though the committee had gotten paid. And so and then there were
I think that was our file. I think I know exactly what file you're talking about.
Well, I might have had more than one.
It was two at the same time with the same committee, if memory serves.
Yes.
It fell off the face of the earth. Yep.
Yeah. So, and I think I had you both, but that was the issue. So if that happens, or sometimes committees are no longer committees for a variety of reasons. And what happens if they're holding the funds? So it's just, my reaction was consistent with what I think I'm seeing here, which is that it's fraught with difficulties. But I'd like to hear if anybody has anything to say, if you disagree, if you think we should discuss this further. I am open to hearing from you.
I think we should not discuss this further.
All right. Anyone disagree with Judge Rohraback's proclamation? I know I agree with him. All right. The second part of that is whether the folks, and you don't have to decide this today, but I don't even know if it makes sense to put it on as other business for the next meeting. But does anyone feel there's any need to discuss this issue at all any further with regard to payment to committees? So I'm seeing a lot of heads shaking no. Is there, so I'll ask it in the alternative, which is there anyone who is not a no? Okay. I believe that takes us to the end of our agenda. Is there any other business that needs to be brought to the committee?
I do
Your
have
Honor, there
one
is,
thing.
oh, I'm sorry, go ahead, James.
George, go for it. I've talked a lot.
Your Honor, a couple of attorneys in our office did ask me to raise this, and it's not something we're going to resolve today. I'm sure everyone is well aware of the situation when there are motions to open on a strict foreclosure, and two motions have been denied. The defendant is required. Well, there's no requirement to extend the law date without an affidavit of good cause being filed along with a subsequent motion to open. Unfortunately, fortunately for everyone involved, most of the judgments we're seeing lately have been sales because there's equity in these properties. However, that then leads us to an issue where there's no mechanism really in place when a defendant files multiple motions to open. Because there's no automatic extension of the sale date, I think that sometimes the court is inclined to grant the motion just to give the defendant additional time to accomplish whatever it is they're trying to accomplish, but then there's no backstop in place to stop multiple extensions of the sale date over and over and over again, which actually ends up being much more costly for the borrower ultimately. But I don't know what the procedure would be to try to address this. I mean, the issue with regards to the stricts resulted from case law and then the practice book, but I don't know that there's anything specifically in the standing orders regarding this. But I just would just have to bring this up to the committee because I know that is something we're running into a lot where we have files where a sale has been extended 3, 4, 5 times in a row upon motions by the defendant. And it's a lot of the times the same basis in all of the motions. So there's really no end game here where they've filed the maximum number or there's no extension. There's always the issue where we can wait on approval of the sale, but that seems to not come up as often as I would like. So I don't know if anyone else has any thoughts on this issue, but it is something that at least a couple of people have asked that I bring up.
Would you like this put on as an agenda item for our next meeting?
Certainly, if we can discuss it at the next meeting, that would be fine.
That would give people time to think about it. I don't know if there's anything that can be done or not, but it will give people time to think about that. Does anyone else have any issue with handling it that way? Anybody want to say anything about that?
I don't have any objection to handling it that way, but I think Attorney General, you might want to write the rules committee, something like that, because
Yeah.
I think it might be above our pay grade.
That's what I was
to-
concerned about, but I was just told about this and asked to bring it up, so I just wanted to make everyone aware of it, but I don't know that there's anything we can actually do
Right.
about it.
Yeah, I think
believe-
go ahead. I'm sorry, Attorney Gentis.
No, I'm just reveling in institutional knowledge. So I think post First Connecticut, the appellate court asked this committee to take a look at it, and a subcommittee was formed and came up with what is currently the 6111G language. And I guess my question would be, I think it would be easier, that's one for some background. So I do think it's within the purview, and maybe that came from the rules committee referring it to bench bar, but I think it could flow upward. But it would be helpful to see the language that you think would, so just give us something to push off of.
Yeah, I tend to agree with Judge Rohraback. I do think that this is probably beyond us. I understand what may have happened previously, but remember the last iteration of the Bench Bar Foreclosure Committee was at the time when things were at a different place than they are now, and it was also larger, and there were referrals made, that kind of thing. We are an advisory committee. Doesn't mean we can't make recommendations, but I do think this may be something that falls within the purview of the Rules Committee, but certainly to give everybody an opportunity to think about it and weigh in, and if there is proposed language that that you want us to consider, it'll give us time as opposed to trying to think about it now and not be able to give that, that extra time to it. So why don't does anyone have any objection to having this put on the next agenda? We can decide whether it's something we can do anything with or not, or if, people want to or not. Does that work?
In the meantime,
Everyone's
Your Honor,
okay
I'll
with it?
see if there's any proposed language that I can send over to Becky, and I'll get that done.
All right. And if there's a particular way that you'd like us to describe the agenda item, sometimes we do our best, but they don't necessarily jog people's memory from the last meeting. So if there's particular language that you think would be appropriate, we can, if you want to send that to Becky, and we'll take a look and make sure that it's something that when 3 months go by and you look at this, you're not like, what were we talking about?
Certainly.
All right. And Attorney Pocklington, you had something as well?
I do. I just want to bring it to the committee's attention so that we can have it in the back of our mind. It will be more discussion on this at our next meeting when we've had a chance to sort of see how it plays out. But with I fill us in on national trends and issues perspectives. There's an issue impacting the industry called it's a recent HUD clarification on their Commissioner's Adjusted Fair Market Value, which is CAFMV, which is causing, for lack of a better way to describe it, plaintiff overbids at foreclosure sales because the bid must be based off of the value as opposed to the debt. We're going to be seeing a number of these over the next several months on FHA files that fit within a certain debt and fair market value band. And our standing orders do not play well with plaintiff overbid situations in terms of how the standing orders are all talking about, closings with a third party purchaser, et cetera, with when funds come into court, when they don't come into court. At this point in the process, at least my office, and I know I've got people reaching out to yours as well, George, are planning on addressing this on a file by file basis until there's some further direction from HUD. The hope is that HUD will change course or provide more clarification, but it is a, for lack of a better description, knowing full these are streamed, recorded, and live, but it is a hot mess with bad interaction of HUD guidelines and local practice. So I just wanted to raise it so that it could be on the agenda for next time in case it would require some level of standardization or alterations to the standing orders, because I've spent a little bit too much time looking at them and they do not deal well with plaintiff deliberate overbids. Accidental overbids, sure, but HUD mandated deliberate overbid is not something anyone ever thought of.
So let me just make sure I understand what your proposal is. You'd like this on as a new business agenda item for the next meeting in case there's something for us to discuss, and if there's not, then we can push it over from
I
there.
think, but also so that we all can keep an eye
Keep it
out
on our
for it
radar.
Yeah.
Okay. All right. Then anyone have anything to say about that? Or otherwise we'll just add it on as one of the new agenda items for the next meeting. Is that good? All right. Does anyone else have anything before I entertain a motion to adjourn?
So as I said at the beginning, I don't know whether it's worthwhile to spend a few minutes at our next meeting discussing the phenomenon of this industry that's coming in and trolling the foreclosure sales and buying properties from people that are on the cusp of having a sale and then purporting to represent those filing appearances on behalf of the people whose properties they're buying.
I already have that. I think we agreed that it makes sense to put that on for new business. It's a good issue. So does anyone have any problem with that being included? Yeah, no. I appreciate you double checking to make sure we don't miss it. All right. Anything else, folks? Well, this was a great meeting today. I will entertain a motion to adjourn.
So moved.
Thank you, Judge Spader. Is there a second?
Second,
Who said that?
that was me, Aaron.
Okay, thank you, Attorney Generous. And all those in favor?
Aye.
Aye, aye.
Unanimous. Have a great rest of your day,
Thank you.
everybody. Thank you
See you.
very
Bye.
much.